My fault, y'all. We ran late. We might have missed off. We might have started where it's at. It's been on for 20, 30 minutes.
But
Oh,
is
we're
everybody
really back.
available? And I'm not
Yeah,
saying
yeah,
we're going to be
yeah.
here 8 to 5
I
every
was
day,
actually about to roll
the
me a
week of the
Dutch and eat.
29th. But is the week of the 29th,
I'm gonna get back to that.
everybody's available to the extent we need all of those days?
The state's available.
Okay. Anybody not? Okay, perfect. Because I'm thinking that at least most of that week, that's what we're going to be doing, which means I am not going to be going to the judges' summer conference, but that's okay. That's okay. Okay. All right. With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. And I'll have to obviously make sure that all the jurors can do that. I don't know what their, pick up kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here and have them. So that's kind of going to be my plan going forward. And it may be that we want to go all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay? So I don't want to be waiting around till 9:30 to get started. 8:45. All right, so that's that. So a couple of things have been brought to my attention that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think. She's not even here today. Yeah, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out, apparently, the closet. So now I've done that for the deputies. They'll be more happy. Okay, next topic. Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions, and we'll just leave it at that for now. There was an issue about, apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening, and that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary?
They don't want thug. Listen to the new hits. They said, don't be in there bobbing your head no more. We ain't doing that. We ain't doing that bobbing the head shit no more. You know what I'm saying?
And if nobody wants to, then we'll just do away with it?
I think it was originally combat boredom.
All right, well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew, okay?
Okay. Sure.
Yes, sir.
Good morning again, Sergeant Master Mr. Huey. There are times where the defendant listen to evidence, interviews, things of that nature.
There we go.
And I've made that available for my clients to listen to some of the interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
So she on shit. And just maximizing the time that I have with my clients since I don't have availability with them outside of court every day. So he's here, we're here. So a lot of times I'll give them an opportunity to review evidence and things of that nature.
All right.
The only reason I want to ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right.
She does not play games.
I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. And one reason I say that.
Hate choosing between vibrant jungle, the sweltering desert, and beautiful beaches. Then come.
No.
Which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it. That essentially said, everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered into order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody has ever seen before. And that's the reason for all of this disruption. But at the same time, you know, maybe some of this can be whittled down, and that is a wild paraphrase of that order, but I think you'll know what I'm talking about. What I want to know is, where are we really? I mean, I know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly. Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence. And I might end up using that. So how about y'all give me a heads up on all of that, okay? And if that is something that y'all could have to me by next Friday for everybody, that would be great.
She is not playing.
Let's see. What's
She is not playing.
on my list?
It seemed like she came to get this shit done.
With regard to kind of just general scheduling,
Listen.
other than the
Listen,
week of the
everybody.
29th,
Gang, I want to see Woody understand with her. She seems like she does not play the shit. She has no nonsense. She want to get this shit done. Feel me? Shout out to OBS for the update. She killed a lot of people. Let's go.
and then I was told, I think Monday through Thursday of August 19th through 22nd. Is anybody aware of time that has already been given to the jury as you're out of court this week? You have this
I
week
think
free.
they have from the plan to
No? Okay. All right. Does any attorney right now know of a date that nobody from your team can be here? And I wouldn't expect that to be the case because y'all are in trial, but no, I mean, anybody getting married? Okay. So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay? All right. All right, what else do y'all think that I need to be thinking about, or do we need to be talking about, or at least raising to talk about later? And anything from the state?
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Okay.
Now.
All right. Mr. Weinstein?
No, Your Honor.
Okay. Mr. Sharp, anything?
There have been, this case, as you know, is enormous, and the discovery is enormous. There are certain, with Judge Glanville, we have some general rulings about some matters, but not particulars.
Okay.
I'm trying to put give a heads up. This is an example, but I don't think this is a situation. I have filed a motion regarding, there was a wiretap in this case.
Okay.
And the judge overruled my objections and stated that the wiretap was legal. He made that finding. However, there are other issues about the wiretap and the particular things said in the wiretap. Some of those pieces of communication may be admissible, may not on an individual basis. Certain things like that, I'm just giving the court a heads up, have not been parsed through to the particulars.
Okay.
And we've discussed like the need to do those things, and some of those things we've kind of kicked the can down the road a little bit, so they're still outstanding.
Okay.
I just wanted to bring it to you.
All right. So maybe when everybody is putting their lists of witnesses and what they're generally going to be talking about together, they could also, I don't know what happened to my mic all of a sudden, they could also include if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all can maybe list out for everybody what that is, because yes, I absolutely want those things to have been determined before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
There's reports that we're still missing. The state has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing them.
All right.
That's been a recurring theme.
All right. If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist, that'll be something we can take up substantively, just so we start out all on the same page. That'll be something maybe y'all can do next week, and we'll take up the week after that as well. Okay, because if we need like 5 days of motions in limine, we need to do that. Okay.
Shouts out to everybody tapping out on YouTube, on Rumble. Shouts out to all my people on Twitch.
Discovery obligations that we have turned over.
Appreciate
all the
that.
discovery that exists in this
Go
case,
follow me
and
on
as the court is
Twitter.
aware, discovery is that which we have. So we have turned that over, and we've actually gotten and requested. We've sought from outside our office any other materials that existed in the universe. We will do as the court has instructed and provide to the court a list of matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And Mr. Shard, I know you've been in my courtroom before, and typically I have, one side or the other list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. All right. And y'all, for any evidence that there hasn't been a ruling on yet that I'm going to need to consider the admissibility of, I obviously am going to need a copy of that. So if I've got 5 hours of some audio to listen to, I don't want to listen to that in court. I want to listen to that beforehand so that I know what we're talking about before we get to court to hash it out. So get me all of that as well. And that'll be more homework for me to do. Okay. All right. Then, so let's go through anything, either Mr. Williams or Ms. Sabasi for your client. Okay. Mr. Harvey, Mr. Steele.
No, not
Okay.
this time, Your Honor.
All right. Okay. The next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody, while we are kind of in this pause, to talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain any kind of plea at any time. It can be a joint recommendation. It will be non-negotiated, since we're in the middle of a trial, but it can certainly be a joint recommendation, or it can be state wants this, defense wants that, or it can be we all want to keep going with this trial. I am here to give everybody a fair trial and everybody a fair shake, follow the law.
At least you want to be fair.
I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that, okay? All right, so I think that y'all have a lot to do and I have a lot to do, and we will plan to get all of our filings and all of our responses in before the end of next week at the dates that I had provided. And why don't we plan to maybe not Monday, but Tuesday, the 30th. All convene here at 8:45 and just start tackling everything that got filed, okay? And we'll plan to go pretty much all day until we finish, every day that week. And by the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week. All right, anything else from anybody?
I have a question, Your Honor.
Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress. For instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said, I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern, evidentially, constitutionally. I don't want it to be, you know, here's my chance to challenge everything under the sun. So I don't know if that answers your question, but it sounds like there are chunks of evidence that everybody has just basically not gotten to yet, and y'all sort of said, all right, we'll get to that when we get to this witness. And if y'all have been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then if that's what the expectation has been, then I wouldn't expect y'all to have all filed all of your challenges. I don't know what's been going on.
Your Honor, that has not been the case.
That has been the case.
Because of the way that the court indicated that the court wanted parties to provide evidence regarding admissibility issues. I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is ripe and what is valid for contesting at a particular moment. I don't doubt those will continue to arise, but I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I.
Okay, so I don't intend to revisit rulings on evidence that's already come in. But for evidence that we know is out there and was going to be introduced a month from now with, witness Jones, if y'all been doing that on a rolling basis and y'all know that there are going to be evidentiary issues with it, things that I would have considered motions in limine, then I want us to all go ahead and voice that now and sort it out so that we know when the witness shows up what can be talked about and what can't be. And I don't know if that gave you clarification. Okay. All right, Ms. Abbasi.
Yes, Your Honor, if I may, I have to disagree with Ms. Love that it's been going along that we've already had motions about what is not admissible. Just to propound on kind of what Your Honor was mentioning and what the task of the defense faces.
I don't think so.
We have a list of 8,000 jail calls. We haven't listened to 8,000 jail calls, and I think probably the majority of them are not relevant. Everyone would agree that they're not relevant. The state's not actually going to introduce all of those jail calls. However, defense are a burden. If we don't raise the objection, it's been waived, and then it comes in at trial.
Okay, so that's why the witness lists with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram is going to be these ones.
Okay. Okay.
And Judge,
Yes, sir, Mr. Adams.
good afternoon. Again, Judge Keith Adams with Mr. Steele for Mr. Williams. Just to, I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just append to what Mr. Biden was saying. For example, the jail calls, the interviews, that generally speaking, there have been hearings on the admissibility of those statements.
Okay.
But the court has oftentimes said, I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that.
Okay.
At that time. The court has routinely been doing that. So not necessarily kicking the can down the road, but addressing issues as they come up. And the court has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that. But there have been routinely times where we simply just disagree and we've had to take those items up. And I think what you would like, what Judge Landfill has asked, is that let's let you know about it as far in advance as we can, and that way you can set aside some time to deal with it without impinging on the juries.
Absolutely. I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can, and litigate everything that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it a million years ago, their updated list that they're going to share with everybody should not include the Instagram post that they know they're not going to use. So, all right. So I will expect whatever filings y'all, I will anxiously anticipate all of them. Make sure whenever you file anything that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay? All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th. All right? Don't leave until you make sure Ms. Rosser has your cell information.
They ain't come back to that.
All right?
Question.
Yes.
Judge Glanville had, for both sides, 2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that that continues. That would be very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing rule. And I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand. And the state knows, we're in the state's case right now. The state knows what it's doing. The state has investigative help. Make sure you have enough witnesses to carry us through each day and that they're ready to go. Again, that all just kind of falls under the auspices of let's be respectful of the jury's
she
time.
just left it straight.
Mr. Harvey.
Can I assume, Judge, that we are going to continue with the opt-out rule so that you're not going to get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if
no, bro, she
if
got
there
this
is
shit
something,
started back
y'all
up
can bring it to my attention.
She ain't dismissing shit.
Otherwise, we'll just keep rocking as before. All right, thanks everybody.
To be honest, remember the press, there was a rule in place for the members of the press.
Yeah, Fanny is, buddy. She already damn near got her mad right now.
We show on camera, we want to make sure that's still in place as well.
Okay,
yeah, she don't fuck with her. You can tell. And Fanny don't fuck with her neither.
Y'all would have agreed beforehand that a particular witness shouldn't be shown on camera. And then who gave the list?
The state has been providing to
yeah, but this retrial shit might fuck all that up. That's what Glenville is.
And
she ain't with the DA shit. So if he lose, is she on the bench?
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown whatever kind of concerns, then they won't be shown.
If he lose while she the judge, that shit might smoke all that shit. Because all that shit that he had to go
it seemed
towards
that
his shit
was kind of
from
a
Judge Glenville.
witness by witness thing, and that there was an opportunity for input.
It all depends on what happened with this trial. A lot of that shit that they was basing that bill off was with the last trial. And that shit was done. They started a new trial.
Yeah.
Witnesses not.
Yeah, I just told you that shit started at 30.
Be provided to us the Friday before.
Yeah, got a new judge.
We would have the opportunity to get to that.
It's damn near picking up where they left off, but it's a new trial.
Make a decision based on his criteria, whether that witness should be shown on television or not.
Right.
And I believe that Mr. Harvey has a standing objection to all witnesses.
That shit got that shit tossed out with that nigga. She started
to
up a
all
whole new
witnesses
thing.
being shown or being excluded? Okay, well.
No witnesses excluded. I don't speak for Mr. Harvey.
All right.
And I'm in concurrence with Mr.
Okay, well, that's why I guess it's being taken up on a case
New trial
witness
date.
by witness basis.
New
So,
trial
Ms.
starts
Love,
July 30th,
then
what she just said.
you're
before.
providing that to the court and the opposing counsel. If there's objection, we're litigating it.
All the witnesses and shit that was already there, but all the rest of that shit got tossed out.
Then
is what I'm
tell
saying.
the press or.
All the shit that was going against Glenville, all that shit got tossed out, bro.
Been providing that list. I will let her explain to the court.
Okay, because I guess I'm wondering how is there a list if there hasn't been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially prepares the list.
All right.
All you gotta do is turn on YouTube.
Good afternoon.
You can hear it, right?
What has happened is the week before, certain witnesses were going to come up the following week.
Okay.
We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as to opposing counsel.
Yeah,
they
different
would
laws in
then
Atlanta.
decide object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state is kind of the preliminary. We think this might be the case list, but Ms. Hilton, do you then give them and here's what our determination was list, or?
So
this is not even a federal RICO, this is a state RICO.
Monday, whether or not that witness should not be shown.
Okay, so y'all you've got your list and you either strike that person off because I said they can be seen, or you just go with what's on there. Okay, that makes sense. So yes, we'll continue with that as well. All right, we're in recess.
Got land on his hair.
Hi, Samantha Fish here. I'm a blues artist here in the Dream Giver.
Is kind of the preliminary. We think this might be the case list.
That means they already previously
Ms. Hilton,
bought.
do you then give them and here's what our determination was list, or?
So normally the court has put on the record that Monday, whether or not that witness should not be
It ain't even a waste of money, buddy. Because around here, you
you
buy the shit
and
you wait for a motherfucker to try to build on it, and then you triple up your money.
Okay, that makes sense. So yes, we'll continue with that as well.
Eliminate everybody.
All right,
you hear me?
We're in
Where the monk
recess.
is? Twin. Yeah.
Guys, wow, this is so interesting. What do y'all think? She is not messing around with time. You know, I'm already making a list of all the things that she's about to change.
Evidently, this ain't McDonald's.
Like
this is
really
McDowell's, my nigga.
respect the jury's time, but also everybody's time.
Because I need
no
my
more
Reese's
food
Pieces,
in the
you hear me?
courtroom, no more music in the courtroom, no more unprofessionalism, no more wasting time, no more being disorganized.
I ain't gonna hold you, but
And
listen,
even to the
this
point where
judge,
they're
buddy,
slimming down.
she came
All of
on
these
quick
defendants'
and
voice
precise. Listen, whatever you niggas is doing, talking about y'all wasting time, talking about y'all got another 100 and some witnesses.
It's so interesting just to see the differences and how another judge will run.
She cleaned that shit clean up. She was like, yeah, we ain't doing all that wasting
her
time.
demeanor
So
was
whatever y'all got
totally
going on,
different, too. She was
figure
kind
out
of
what y'all gonna
nice
be
and
using,
pleasant.
what evidence
The other
y'all got,
judge,
what y'all gonna be
Glanville,
using.
was more
Because lady,
this,
they got
that,
like
really
1,000 hours of
lay down
fucking
the law.
inmate
She was
calls,
super sweet. She was like, hey man, you know,
Judge that
we're just trying to get through this. And if some of y'all want to plead out, let's plead out. All right. She's trying to lessen the load. But you know, she's not coming across as if she takes a lot of nonsense, right? She's saying, hey, you know, regardless of how we did some of the things before, this is how we're going to do some things now, and that's good. She's kind of putting her own stamp on it.
Okay, if you folks want to turn your instructions back to number 33,
and you guys
we'll read
can
the
see
last
that with under Judge Glanville, there were just a lot of loose ends that were not tied up. So she's trying to close those loose ends. I want to give a big shout out now that we got 6,000 people. Oh, we got 6,000 people in here. 6,300. I'm going to let y'all in. I'm not
And he
sure.
was biased anyway. It's good chat. We gonna go on this mom witch trial, murder trial. Let's get into it.
May be inaccurate or incomplete. Upon reaching a verdict, leave
Word
the
on my
notes in the
baby.
jury room and they will be destroyed. Instruction number 34. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website such as Facebook, YouTube, Snapchat, Instagram, or Twitter to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Your cell phones must be turned off during deliberations. If the length of deliberation causes you to need to make a call regarding personal arrangements, such as childcare or other scheduling issues, you may make such calls when the jury takes a break and temporarily stops deliberations.
but you must not discuss the case until after you have reached your verdict and I have released you from jury duty. Instruction number 35. When you begin your deliberations, you should select a foreman or forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong, but do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are judges of the facts. Your sole duty is to find the truth and do justice. Instruction number 36. I am giving you one verdict form. You will find only one verdict on each count. When you have agreed upon a unanimous verdict and the foreperson has signed the verdict form, please notify the court attendant. This case is submitted to you this 19th day of July, 2024. Okay, just a few additional pieces of information, and then we will send you out for lunch and deliberations. First of all, we've indicated to you that the exhibits will be available to you. They will go back with you to the jury room for you to examine. And
Shouts out to everybody that's on
make sure
YouTube.
you don't alter,
It's on
change,
Twitch.
destroy
Appreciate
them
y'all
in any
again.
way. They need to come back
We
to
got this
us
new trial
in the
going. I
same
don't know this
condition.
one. Just started today.
All
Let's
exhibits
get it.
other than the hatchet will go back with you. If you want to see the hatchet, let the court attendant know that. In that case, one of the deputies will come back into the jury room to let you observe the hatchet. Please understand, while the deputy's in there, there shouldn't be discussion or deliberation about the case. You can look at the hatchet all you want, spend as much time as you need. When you're finished, tell the deputy thank you. He will leave again with the hatchet, and then you can start discussing the case. We do that because no one should know what your deliberations are and what you're discussing about this case, even the deputy who brings in a piece of evidence. I indicated to you about your phones. When you start deliberations, the court attendant will keep your cell phones. If you need to use your phone at some point in time, let the court attendant know that. She will let you use your phone. When you've finished, you'll give it back to her and resume your deliberations. Deliberations can only happen when all of you are together. If someone needs to use their phone, use the restroom, step outside to smoke a cigarette, anything like that, deliberations about this case have to stop. You can only discuss the case when you're all in the same room talking about it. Throughout trial, I've been telling you about the admonition. This is the point now where part of the admonition changes. I had been saying, don't discuss this case with each other. Obviously, that changes. I had been saying, don't draw conclusions of any kind. Obviously, that changes. You still can't talk about it with anyone else. You still can't do anything to acquire any information outside of what you got through the trial process. Last thing is, there are 14 of you. By law, we have a jury of 12. We randomly selected who the alternates were going to be. Juror number 31 in the front, ma'am, you will be an alternate. And juror number 48 in the back, in the white shirt, you will also be an alternate. So that means when we're finished here and I excuse the jury, the two of you are released, entirely released from the admonition. You can talk to anybody about this case that you want except the other 12 jurors. You can choose not to talk about the case if that's your choice. If you want to know what the verdict is, write your name and your phone number.
When we listen, we are unconfined, free to travel the world.
After I take the verdict, I will call each of you if you would like to know and tell you what the verdict is, give you a chance to ask me questions or offer any complaints that you have. If you don't want me to call you and you don't care what the verdict is, that's fine. Then don't give your packet with your cell number to the court attendant. Make sure it's clear. The two of you should not express any thoughts at all about this case to the other 12 jurors. When we're done here, if you have anything in the jury room, you'll go in and get it, and then you're free to leave. Go home, go back to work, whatever you need. We will not be calling you back in, and you're released, but just don't express any thoughts about the case, any opinions to the other 12 jurors. The 12 of you should not start talking about this case in any way until the two alternates have left. Okay, I should say, I think you all ordered lunch, and even for the two alternates, if you want to stick around out in the hall, not in the jury room with the other 12, and wait for your lunch and take your lunch, you're welcome to take your lunch on the state. If you don't care, you can take off and skip out on your lunch. All right, I have the verdict form. I am going to give this to the court attendant, and she will take you to the jury room at this time. Again, wait for the two alternates to gather their stuff and leave. If the two alternates don't have anything in the jury room, you're welcome to take off immediately. All right.
Wix gives you the power.
This instance, state and federal, how the hell is he supposed to make it? Tell Woody, man, get on YouTube.
I'm gonna start where
It
we
might
start.
be about 100 short, but I'm gonna go on and let y'all in. When y'all come back, let me know. When y'all come back in, let me know what you think of the new judge. Are you feeling her? Is she better than Judge Glanville, or is she worse? Is she better or is she worse? What do you think? What do you think? She's trying to give a little bit of a breath of fresh air, right? And trying to get through this. And it's a messed up situation. She does not want
when you know
this
the
case.
man, you know the man. You just gotta
Again,
be the man
guys,
and know the
this
man.
case is messed up. And you never want to be the second cook in the kitchen. You know,
I ain't
you
gonna
never
lie.
want. You always
That
want to
seem
be
like-
first. Shout
that
out
seem
to
like
Ray
the price
J.
going
I
back
hit it
down again.
first. You
That's
don't
when I
want to
stopped selling
come
weed the first
in
time.
the sloppy seconds and you're like, oh my God, it's so messy. No, you want it when it's clean. But she didn't really have the opportunity to make a choice. You know, these judges are randomly assigned. And, you know, she got away with it. They were assigning a few other judges, but then they were recused.
10 years ago,
And so now
$15.
she's up to bat. And apparently it doesn't seem like we haven't heard, well, let me take that back now, because there were, I think, 1 or 2 motions that were filed that were trying to recuse all of Fulton County judges.
Yeah.
And she is a Fulton County judge, but, you know, she's like, well, I'm here. Let's try to make the best of it. So we learned that Woody presumably is going to be back on the stand on August 5th. And I don't know if y'all have seen, man, Woody, and his name is pronounced Woody. I learned that. Shout out to the Danza Project. They did an amazing video with him, interview. It was amazing. And y'all saw him on that 20v1. That damn thing got what, 2 million?
2 million views. Yeah.
2 million views. Woody's been killing it. And a lot of people are like, hey man, you know, Woody, you know, he's talking too much. He's on the stand. He needs to chill out. He needs to do something else. He needs to be quiet. Y'all are saying that about Kayla too. And Kayla and Woody, I would think, I'm going to say that those are two different situations, guys. Kayla's situation, Kayla's an attorney. All right. Kayla can get bread, in many ways. But the problem with Woody is that Woody's from the streets. All right. And Woody has been to court numerous times. He's been to jail numerous times. And he's got a record. He has been not only to jail, he's been to prison. Not only state prison, but federal prison. All right. So when you think, oh, well, I'm Woody and I'm going to go apply for a job, what do you think his prospects are?
Yeah, that's a good point.
That's the thing. And social media is the new equalizer. Like, it doesn't matter if you are a straight A student or you are a convicted felon, guys. If you get on YouTube, you can make this money. How many people think Woody should just be quiet, or how many people think Woody should try to run up a bag? What do you think? What do you think? Do you think Woody? What do you think, AV? What do you think Woody should do? Now, he is on the stand testifying.
Yeah.
What's your take on it?
Yeah, honestly, I think he should wait. But at the same time, he's hot right now. So he's taking advantage of it. I mean, does it compromise the case? But we also have to remember, Woody is not on trial. Woody is not on trial. He's a witness.
Yeah.
He's a witness to a trial. When he first started, coming out on social media, I was more concerned for his safety. Because I remember, a few weeks back, one of his, friends had gotten murdered. So I was more along the lines of thinking of that, because Atlanta is very small. I was down there a few weeks ago, and people are coming up to me like, "Hey, you're AV," and I'm like, "I am."
Right.
And, like we would hang out sometimes. People would see you first because you're taller, but it's like people will really recognize you. And he was going through that. Like, people were coming up to him, and he's like, "For y'all safety and mine, you may not want to run up on me."
Don't run up on him. Last time those dudes ran up on him, started grabbing his zipper. He was like, "Oh, it's on," you know?
Yeah. So
reaches down and grabs your zipper.
It's a little close.
That's when you know. Well, AV says he should kind of chill out, and Lord knows the judge, especially Glanville, wanted him to chill out, and the state definitely wants him to chill out. But I'm going to disagree, man. I'm going to disagree. I think Woody should just blow it all up, because, guys, Woody, he's in his mid 30s. He's got these kids, and there's no way for him to make a way. Mm-hmm. Any type of job that he gets is going to be an hourly job. Somebody write inflation in the damn chat. Has anybody noticed the inflation? Somebody write recession. All right. It is so tough out here, guys. It is so tough. Let me tell you something, man. Not to put too much sauce on it, but when I got on YouTube, my first YouTube check was it took me a year and a half to get. In a year and a half, your boy made about $130. And I was like, this is some bullshit. But when they gave me the $130, I was like, well, at least it's a cell phone bill or something like that. Guys, you got to remember, Woody doesn't have any options. All right. And if you say, well, that's Woody's fault, well, fair enough. Woody has exposed a lot of the corruption. Woody has been the victim of so much corruption down here. But it needs to be said, Woody himself has not been an angel. And I think Woody would tell you that he's made some decisions that are not great. But then you look at his history, both his parents dying when he was young, and he's basically just out here with a 10th grade education. It's easy for us to judge when, it's not us with a 10th grade education and a disability and trauma and the victim of so much corruption and the victim of some poor decisions. When you mix all that up together and you got kids, come on, what are you supposed to do with your life? I'll show you guys, man. When I started YouTube, I was like, I didn't know how much money you could make. And then I started doing this, and these are my analytics, guys. Now I don't know if you can see this. This is how much your boy make, $116,200, but this is for half of the year. This is for
This nigga
half of
making
the year. And I'll be
116,000
honest
on
with you,
YouTube. We
this ain't
gonna
even
book him,
all of the
dog.
money.
We gonna book him. We
Right?
need to
This
turn
is
it. It's
116,000.
like, nah, he's no joke.
And so if Woody has the opportunity to get $116,000 for half of the year, or even for the whole year, or even 100,000 or 80,000, this much is more than he's got now. Woody ain't got no job making 80,000 a year. What if he could get 116, right? Or, and this ain't all the money, your boy got a course. All right, I made 154,000 apart from the 116, 115 for the 154,000 for the course. Also, I was on Rumble, made about 57 a year from Rumble. So when you add it all up, guys, just to let you know, man, for half of the year, your boy made $327,000. How? Doing this live stream shit. Straight live streaming, straight bullshit. And y'all know your boy be on some bullshit. Does it look like to you I'm doing anything scientific? I can't do any of y'all's jobs, man. Truth be told, I can't even do math. I can't add. Woody, you know, he's got all these records. He's got all these prison stints, state and federal. How the hell is he supposed to make it? Tell Woody, man, get on YouTube. Get on YouTube. This is where I'm at with mine. 327,000 for half of the year. Somebody write Woody in the damn chat. Mango says, what about them taxes? Them taxes are a bitch. All right, I gotta pay them.
Yeah.
Them taxes are a motherfucker.
Yes,
but if you've got a job, you got to pay the taxes anyway. And I get the money first. See, y'all don't get y'all's money first. Y'all's employer take out the tax money. I get mine first.
Hi.
And then I get to file a little extension, or I get to buy.
Let's see what the feds got look on. Feds, we got that little nigga PDF note, dog. I'm tripping. Motherfucking riding, bro.
Man, what's up, everybody? It's 1090J. I'm rocking with y'all, and y'all rocking with me. And for this video, we're gonna be speaking on PGF Nook being indicted by the feds in Chicago for 2 back-to-back carjackings that took place in less than 30 minutes. PGF Nook, one of Chicago's rising drillers, may have just ended his own career. The man behind the mask, identified as 22-year-old Virgil Gibson, has now been officially indicted by the feds. It's been 2 years since Nook dropped his hit song, gaining over 100 million views and instant stardom in the city. With a cosign from Lil Durk to being brought on stage by Polo G, Nook seemed like he could possibly be next up from the rack, but a series of arrests, along with his views going down, would seemingly lead the rapper to crashing out. Back in August of 2023, Nook was arrested after a block with a switch was found on the floorboard of the car he was driving.
That's the rapper PGD people right here.
I don't know who you talking about.
According to a Chicago News article, police stopped the vehicle because the plate on the
called that PGD
car had been flagged for impound after previously eluding police, meaning Nook was caught riding in a getaway vehicle. According to the news report, the person riding passenger with Nook told police it was Nook's gun, and Nook told the police it belonged to the passenger. Obviously, the gun belonged to one of them, but neither one of them wanted to take the charge, and according to the article, they told on each other to police. Nook would be arrested, later freed on pretrial release, and 8 months later, arrested for double carjacking plus kidnapping. On April 7, 2024, federal prosecutors alleged Nook carjacked 2 people within 30 minutes. The first attack was on the south side of Chicago at a gas station in the 5900 block of South Morgan Street in Inglewood. It's alleged that Nook, armed with a handgun, took a 32-year-old man's Chevy Malibu at gunpoint. 30 minutes later, Nook arrived at a gas station in the 8300 block of South Cottage Grove, driving the man's Chevy Malibu. Nook allegedly got out of the stolen car, opened the door to another man's Kia Optima, and forced him into the passenger seat at gunpoint. The 35-year-old victim was forced to transfer money from his bank account, remove some of his clothes, and then get out of the car. Covert Chicago police later spotted the hijacked Kia in the 1600 block of West 55th Street, while PGF Nook was found hiding in the janitor's closet of a nearby phone store. He'd be found wearing the same clothes as the hijacker that would later be seen on surveillance video. Nook would be charged with 2 counts of vehicular hijacking with a firearm, armed aggravated kidnapping, and aggravated unlawful restraint. But the biggest blow would be when the feds announced the indictment. On Tuesday, July 16th, a federal grand jury indicted Nook on 2 counts of carjacking, 3 counts of brandishing a firearm during a crime of violence, and 1 count of robbery and kidnapping. The charges in the indictment carry a maximum sentence of life in federal prison. As everyone pretty much knows, when the feds become involved, it isn't a matter of if you're going to prison, but how long you're going for. Let's not forget that at the time of the broad day carjackings, Nook was still on pretrial release for his state gun case when he was caught with a switch. At this time, he hasn't been federally charged with the switch, even though his charges would appear to state 3 counts of violent crime.
Yo, listen, how you gonna be on pretrial? You did 2, not 1, but 2 armed carjacking. No, man. Actually, you supposed to get money. Sure, dog.
/drugs/machine guns, Within the indictment, it clarifies he has 3 counts of brandishing the weapon during a crime of violence. PGF Nook is currently being held in the Cook County Jail within the infamous Division 9. This would be home to the max custody inmates with the most violent cases in Chicago. Nook's Instagram would be flooded with comments about him being a crash dummy and ruining whatever was left of his career. It's hard to imagine this playing out in any way other than bad, as the amount of evidence is overwhelming. Not only were the crimes captured on video, he was arrested wearing the same clothes as the person committing the crimes on video. He was arrested nearby one of the stolen vehicles, and he had one of the victims wire him money to an account, possibly his own account, because if he's desperate enough to carjack in broad daylight, he might be dumb enough to send money to himself. Federal documents would state Nook does have a lawyer, but what's the fucking point with all the shit that's against you? All she's doing is overseeing the plea deal he's about to take, because trial would end with a life sentence, and Nook really has nothing to bargain with, meaning whatever the feds offer him is most likely what he's gonna have to take. At 22 years young, it's likely Nook won't be seen again until he's well into his 30s. It's highly unlikely he'll be let out on pretrial release, knowing he's still pending a gun case in the state's courts. See, this is the hardest part of living the lifestyle. Nook quickly became the biggest name in his circle. Money started coming in, shows were getting booked, interviews were being done. Nook saw the rise, but he couldn't predict the fall.
Spectrum Mobile's new deal is so good it's a work of art.
Love the.
He had so much in his first video that they weren't even as impressive in the next 20 songs. He was left in the shadow of his only hit, his fan base would slowly turn, and now he's left to see who around him was actually rocking with him. Nook can be seen with his mom, who's clearly an OG GD or an OG gangster disciple. The son of a gangster, Nook would describe in an interview how his own mom shot back at his ops after his house was shot up.
It was a point where my mama had to shoot, you feel me? Like, I want that type shit. I never be at the crib, but they'd come to my crib, try to shoot the house up. Tell them mama had to start shooting, like, that's to defend her crib type shit. Like, that's type of shit that made me go harder in the streets.
Some could say Nook was doomed from the start, being raised into the gang-banging world of Chicago, while others could say he had a head start.
That's crazy. And his mom. Bro was set up not to go. It's fucked up, man.
In the streets. Being that he's young and hasn't been to prison, his next move will have to be his best. One of the biggest mistakes for first-time or younger inmates is to not accept a plea deal. While it sounds easy, actually living through the experience of signing your name on a piece of paper, knowing you're signing away years of your life to be spent in prison, it's easier said than done. But not signing results in trial and a harsher punishment. Meaning Nook could be offered 10 years, deny it, be found guilty at trial, and sentenced to life because in his mind, he hoped his lawyer could find him a way home. With over 90% of federal cases ending in a plea deal, it can be expected within the next 6 to 12 months, Nook will sign his fate and the case will end. We'll just have to wait and see how it plays out. Now I'm not gonna lie, when What Up dropped, that was my shit.
That's crazy. I watched that 3 times. So that was stupid. That was very stupid. That was stupid. Let's fuck around, man. Let's fuck around, man. 15, man. I get him tomorrow. Let's fuck around. I'm picking up on Sunday. Thursday is a weird day though. Why Thursday? Thursday was a weird ass day. In the long run, that should get you though, gang. I said in the long run, that should get you though, gang. Oh man, bro. Listen, man. Let's go to it. There we go. They got me, gang. So, and then, thought it was in there, we wasn't in there. Yeah, no. I really not sure. It's me, God. It's only me, God. It can only be me, God. I'm trying. It can only be me, bro. It can only be me, bro. Thank you very much for the great, bro. I got shit, man. Oh. It's that's playing. Don't fly it. Don't fly it. Don't wiggle, bro. We locked in, though. You can have we logged in. I'm logged in, bro. We logged in again. We logged in again. I appreciate it. Like, no, I'm going.
Use this time for some target practice. Real things coming soon.
Oh, it's the game.
Enemy soldier incoming.
We gotta make sure it's running good, right? Take it there, but I don't know how phone. Let me get it.
Hell's almost full. Enemies are dropping into the area. Watch the skies.
Yeah, I'm gonna work on very. Eddie one. Oh, my last shot, bro.
Enemies dropping into the area.
See me. He saw me, buddy.
Prep time's over. Now you deploy to the war zone.
He saw me, buddy.
Gang's all here. Head shed gave the green light. We're deploying you to the front lines. Gear up, grab your chutes. You are cleared hot on all threats. Watch your ass down there.
Let's roll. Resurgence. Survive the timer to secure redeployment. Earn points to speed up the countdown.
LZ Mark, cancel that.
Hostile counter UAV overhead. Enemy soldier incoming. Hostile Mosquito is online. Enemies are dropping into the area. Watch the skies. Enemies deploy the counter UAV. Enemies dropping into the AO. Hostile counter UAV overhead. Gas is inbound. Enemy soldier incoming. Hostile Guardian has been deployed. You got a loadout drop inbound. Enemies are dropping into the area. Watch the skies. Five remain. Solid work so far. Gas is closing in. Enemies deployed a counter UAV. Hostile counter UAV overhead. Enemies dropping into the AO. Fire sale active. Buy station prices have been reduced. Enemies deployed a counter UAV. Enemy soldier incoming. Resurgence is about to end. Make it count. Gas is moving. Sale's over. Adjusting prices. Resurgence has been deactivated. Supply crates are restocked. Advise you load up now. They hit us hard that time. Let's regroup and get back up there, yep? You made it to the top 10. Gear up fast, we're about to get evil.
That boy ain't.
Enemies dropping into the AO.
Close one.
Enemies are dropping into the area. Watch the skies. All stations, green light. We are deploying to the war zone. Resurgence. Survive the countdown to earn redeployment. Secure kills to speed up the timer. Think we got their attention with that one. Move in. Enemy soldier incoming.
Hostile Mosquito is online.
Friendly loadout drops on the way.
I see an enemy.
Only 25 left. Keep up the good work.
I see an enemy.
sale is active. Buy station prices are adjusted. Resurgence window is ending. Watch your 6. Gas is inbound. Prices are back to normal.
And in between the two. No big.
Resurging. Go get your revenge.
And I missed it.
Resurgence has closed. No more second chances. Enemies dropping into the AO. You're in the top 10. Come out. You're losing ground. Move it.
Need mid-gun rounds. Gas is closing in.
moving in. Less than 5, we're still standing. That victory's ours next time. The enemy took that
lucky,
one.
bro.
We'll get them back.
Lucky, bro. Lucky, bro. I should have been there. I got a last minute. Let them go. I got wild plays. Don't move on my left. I'm not there. Don't move. Don't move. Don't move. I see that shot. I'll do that. I'll do that. Shot it. I ain't gonna be able to do this shit. I got about 1,000 bucks.
Check your gear and weapons. We'll be deploying shortly.
Close one.
Enemy soldier incoming. Playtime's over. Stand by for deployment to the war zone. Resurgence. If you stay alive till time expires, you've secured redeployment. The more points you earn, the faster that clock's going to tick.
Hostile counter UAV overhead. Hostiles deploy the Mosquito. Enemies deploy the counter UAV.
Enemies are dropping into the area. Watch the skies.
Cluster mine out.
Hostile mosquito is online.
Enemies dropping into the AO. Gas is moving. An enemy squad's hunting you. Stay sharp.
Scanning. Identity confirmed.
Lost track of you. Good work down there. Loadout drop headed your way. Remaining. Enemy soldier incoming.
Moving here.
Might jump down.
Moving here. Cancel that.
Not sure.
Gas is closing in.
Fuck off. Oh, Oh, I forgot it was a road right there.
You're back on station. Go get after it. Fire sale active. Buy station prices have been reduced. Get ready. Resurgence window's about to close. Gas is inbound. Fire sale's over. Adjusting prices.
Chat, I gotta go. Gotta get my jump. There's a couple more quick buys.
Be advised, resurgence is no longer active. This is for keeps. Enemies are dropping into the area. Watch the skies. Keep the pressure on. 25 remained. Failure ain't fatal. Just an opportunity to do better.
I'll be back in like 30 minutes. You heard? Let's get to it.
You got gas moving in.
I appreciate everybody for tapping in on YouTube, the Rumble, the Twitch. You know what I'm saying? Appreciate all y'all. And we gotta get back to those crowds. Because you do know we be streaming these live for travel. We a little late today, but we back on time. But appreciate everybody, man. Appreciate everybody. But y'all be back in about 30, 40 minutes. Y'all wanna come tap back in? And listen, man, if y'all love Call of Duty or Xdefiant, I like any of these multiplayer games because I got the finals, I got all that shit on here. So if y'all want to tap in, y'all want to lock in, hit it in the chat. We can get live on that shit. You know what I'm talking about? Welcome me, it's your boy AC 315, this is where we drive.